Hello students, welcome to another lecture of Indian Contract Act 1872. In our today's lecture, we will be going through another important essential of a valid contract given under section 10, and that is consideration. Now the word consideration, though it may sound to be a technical one, it is dependent upon a simple principle which in Latin is known as quid pro quo, means something in return to something. As we have already been seeing for last couple of lectures, when you talk about a valid contract, there are two parties or more than two parties which are involved in a legal relationship, whereby one party promises the other party to do something in return to get some benefit from the other party. And this something which I just mentioned in legal terms is considered to be as consideration. So consideration is one of the essentials of a valid contract, and any contract without a valid consideration is considered to be void and will not be enforceable at law. It is considered to be a foundation of a contract, and the Indian Contract Act enforces only those promises which are made for consideration. The word quid pro quo here means something in return to something. Now, the word something means it should have some value in the eyes of law. Need not every time it be money consideration, not necessary it should be any currency which is exchanged for goods, but it can be anything which has got value in the eyes of law, which law considers to be something important for entering into a legal obligation. And any agreement without a valid consideration is void and it cannot be enforced, meaning a party cannot go to the court and say that we had entered into a contract or we had entered into an agreement, but if either of the party has not paid the consideration, such contract cannot be asked for any relief if the other party breaches the contract. Now, the Indian Contract Act has defined the word consideration under Section 2, Clause D, wherein it says that when, at the desire of the promisor, the promisee or any other person has done or abstained from doing, or does or abstains from doing, or promises to do or abstains from doing something, such act or absistence is called as consideration for the promise. To put it down in simple words, that consideration is something of value which the promisee has given, gives, or promises to give in return for the promise which is made up by the promiser. Now, there was a landmark judgment in the year 1875, quite old judgment, which is Curie versus Nissa judgment. It was delivered by the English courts, wherein consideration was defined as a valuable consideration in the sense of the law may consist either in some right, interest, profit, or benefit which is accruing to one party, or some forbearance, determinant, loss, or responsibility which is given or it is undertaken by the other party. So, consideration is some sort of a price which is paid for which the promise of the other person is bought, and the promise thus given for the value is enforceable. That value should have some value in the eyes of law. Certain things might be important for me, but law might not consider it to be important. So, when you talk about consideration in our further slides, we will go through certain examples of consideration. We will try and understand what are the various types and which consideration is considered to be valid under the Indian Contract Act. These are the types of consideration which are considered to be legal in India. The first type is past consideration. Now, if you read the definition of consideration given under section 2 clause D properly, it goes on using various terms. For example, has done or has abstained from doing, or does or abstains from doing, or promises to do or abstain from doing. Here you will understand that consideration need not be given at the same time when the contract is entered into. There might be a possibility that I might give a promise today, I might give the consideration today, but the other party would be giving it to me after 1 month. To give you a small example, it might happen that I have booked a flat under construction building. I might have given 80% advance to the builder. Not necessary that the builder will give me the possession of the flat immediately. Under our terms of contract, he might give me the flat possession after, let's say, 1 year or 2 years as well. Whereas under certain circumstances, on daily basis, if you want to purchase, let's say, 1 kg of sugar, you go to the shopkeeper, you give him 50 rupees, he will give you 1 kg of sugar simultaneously. So consideration need not be every time given simultaneously along with the promise from the other party. In India, we consider valid that if a consideration, even if it is a past consideration, will be considered to be valid under the Indian Contract Act. But when you talk about the English laws, under English laws, past consideration is no consideration, and it is only the present or future consideration which will have values in the eyes of law. Now let us go and understand what you mean by past consideration. The word itself suggests that when a consideration for the present promise was given before the date of the promise, it is said to be past consideration. Now past consideration, if it is given at the request of the promiser, will support a subsequent promise. Now, let's say for example, if the employees do some extra work in consideration where a bonus is promised to them by the employer, it will be considered to be past consideration. Another example, let's say if you see you have gone out with your friend for swimming, and if you see your friend drowning in the water, you don't go and save your friend with some expectation of a reward in exchange, but you save your friend just out of humanity. Later on, if your friend promises that you have saved my life, I will give you some reward, that can be considered to be a valid consideration for your agreement, because you have already performed your part of obligation, and then the other party promises you to give some consideration in return. Whereas when you talk about present consideration, the name itself suggests that such consideration is given by both the parties simultaneously when the promise is delivered. So when the consideration for the promise is given simultaneously with the promise made by other party, it is considered to be present consideration. It arises where there is a promise, for example, to pay for the goods which are sold and delivered immediately. Whereas when you talk about future consideration, when the consideration is to move at the future date, it is called as future consideration. It is called a promise for the promise, meaning mutual promises, for example, to marry or promise to pay money at the future date for the goods which are delivered today are the examples of future consideration. To give you the latest examples which you might be undergoing on everyday basis is that, let's say you book something on Flipkart today and you expect or you are going to pay as cash on delivery. That means you are booking today, you are going to get delivery, you are going to pay immediately upon the receipt of your goods. It is considered as present consideration. Whereas if you have paid the money today via your net banking or via your card payment, and after 1 week period you are going to get the goods from Flipkart, that becomes your future consideration, because you have already performed your part of obligation and the other party is going to perform after 1 week. So when you talk about consideration, existence of consideration in your agreement and contract is must. However, it can be performed either earlier or simultaneously or at a future determined date. So law only goes on saying that you must have consideration in your contract. How and when should that consideration be paid, that is left to the parties to decide. As per the mutual agreement between the parties, they can go on deciding as to when and how the payment of consideration will be done. It might be exchange of services for money, it can be exchange of goods for money, it can be exchange of services for services. All of these things are perfectly valid considerations under the Indian Contract Act. Let us now go ahead and try and understand what are the essentials of a valid contract. The first essential of a valid contract is that the consideration must move at the desire of the promiser. Now, the word must move typically means that the consideration must be decided, or the consideration must be delivered, or the consideration must be decided and talked about only at the desire of the promiser. Meaning, if there are two parties to the contract, the promisor is the one who goes on expecting the consideration or deciding the consideration. Any third party cannot decide what should be the consideration for that. Now, to give you a small example, let's say if A loses his son and B voluntarily goes for search and finds the boy. Now, B cannot claim any reward for finding out the boy on his own because he has not done the work of searching a boy at the A's desire or request. If I have to enter into a contract with other party, I should be the one deciding what will be the consideration. No other party can go on deciding what the consideration should be, because it is my will, it is my free consent which I have given for the contract. Another important essential of a valid consideration is that consideration may move from promisee or any other person. Now, you will have to understand the difference between these 2 points. Promisor is the person who has to decide upon the consideration, because promisor is the one who initiates the contract. Meaning what? The offerer, if you remember the parties to the contract, when we were discussing offer and acceptance, we said that offerer is the person who gives an offer to the offeree, and once the offeree accepts the offer, the offeree becomes the acceptor. Meaning, it is the offeree who starts or begins the contract, who is the initiator of the contract. According to the Indian Contract Act, it is the offerer, that means it is the promisor who has to decide what will be the consideration. So, when the offerer is given an offer to the offeree, the offerer will have to specify what will be the consideration, how much will be the consideration, and it is the offeree who has to agree upon that consideration. So, when there is a valid contract, the offerer becomes the promisor, and that is why the first point says that the consideration must move at the desire of the promisor. However, law says that the acceptor to the contract, that means a person who has accepted the obligation, the consideration can be paid by the acceptor, that is the promisee, or by any other person, even though that third party is a stranger, even though that third party is not even associated with the contract. I'll give you the details of this landmark judgment, which is known as Chinnaya versus Ramaiah case. It is again an old case, 1882 case, but it is still considered to be a valid case today. Now, in this case, what had happened was that there was an old lady, and she had a daughter. She had a lot of property in her name. Before dying, she made a contract with her daughter, wherein she gifted her entire property to that daughter. Now, this daughter and the mother who had entered into a contract, along with many assets, many properties, there was also a flat, that means there was also a house in the name of the old lady, which she had transferred in the name of her daughter. But this gift deed, which was entered between the mother and the daughter, it had one condition in that contract, and that condition was that this old lady had another sister, and she had made it clear in the contract that whatever money you are getting out of that flat, which you have to give it on rent, that rent you will have to give it to my sister. That was the condition which was mentioned in the contract. So, in total, in our case, there were 3 parties: the old lady, the daughter of the old lady, and the sister of the old lady. As per the arrangement between the daughter and the mother, the daughter had to pay certain amount of money every month to the sister of that old lady. So, the contract here was between the old lady and the daughter. The sister was nowhere as a party to the contract. Now, till the time the old lady was alive, the daughter used to pay monthly rent to the sister as per the condition according to the contract. After the old lady passed away, the daughter stopped paying the amount to the sister, and therefore the sisters filed a case in the court saying that the daughter has breached the contract. She was supposed to pay me some amount of money as rent on monthly basis, but now she has stopped paying me the amount of money. Now the daughter, what she said in the court was that she said that there was a contract between the old lady and her daughter, but there was no legal consideration from the sister. The fact that the old lady gifted the property to the daughter was only obligated towards that old lady. The minute the daughter was paying some amount of rent to the sister, there was no consideration which was coming from the sister. And if you remember in the beginning itself, I said that in case of a contract, consideration must come from both the parties. So the daughter said that I am giving you certain amount of money as rent on monthly basis. What am I getting in exchange from you? And the reality was nothing. The sister was not giving anything in return to the daughter. But the court in this case rightly held that even though the sister was not giving anything in return to the daughter, the old lady had already transferred her property to the daughter upon a condition that every month she has to pay certain amount of rent to the sister. And that is why, even though the consideration did not come from the sister, but the consideration, that is the property, had already come from the old lady. So the meaning of this essential condition is that consideration may move from promisee or any other person. So in this case, even though the daughter and the sister had to have a certain arrangement wherein daughter was supposed to pay some amount of money to the sister, even though the sister was not giving any consideration to the daughter, the consideration had already been paid by the old lady. And that is why the court declared, or the court ordered, that the daughter has to pay certain amount of money to the sister. That is the meaning of the essential consideration may move either from the promisee or any other person. Now I hope this distinction between these 2 points is clear with everyone. Now the third essential is consideration may be past, present or future. We have already discussed this point wherein we said that in India consideration either can be past, or it can be present, or it can be future consideration. The fourth essential is that the consideration shall not be illegal, immoral or opposed to public policy. Now this is an again important topic, or this is an again important wordings, wherein according to section 23 of the Indian Contract Act, the consideration which is given for the agreement, it must not be unlawful. If the consideration is illegal, or it is immoral, or it is opposed to public policy, the agreement will become void and it will not be considered to be valid consideration. For example, an agreement to destroy somebody's property is void and it cannot be enforced, because to destroy somebody's property or to destroy somebody's house or car is illegal in India. Likewise, if I have given 10,000 rupees to one person, I have told him to sell me certain drugs. If he takes my 10,000 rupees and runs away, I cannot enforce my contract against him, because in return what consideration I am getting is drugs, and selling and purchasing of drugs in India is illegal. So when you talk about consideration, it should not be illegal, it should not be immoral, and neither it should be opposed to public policy. For example, if I give certain money to a person and I tell him that you go and kill Mr. A, who is my competitor, such consideration is considered to be illegal as well as opposed to public policy, because murdering somebody is illegal, so that cannot be enforced under law. Likewise, the next essential condition for a valid consideration is that it need not be adequate. Now, the word adequate here means that it must be there, but it should not be necessarily up to the value of the consideration which the other party has paid. I'll give you a small example. Now let's say nowadays if you go and purchase any two-wheeler bike, a first-hand two-wheeler bike, the showroom cost of any, let's say, Access or Activa, you will find it ranges from 70,000 to 80,000 rupees somewhere. Let's say there is a friend of mine who wants to sell her Activa. I go to her and I request her that if you want to sell me the Activa, I am ready to purchase it, but I want to purchase it at a lower cost. Now that being a second hand Activa, she says instead of 80,000 rupees, I am ready to sell you at 5,000 rupees because I want to dispose of this Activa, I don't need it, and you are my friend, so I am ready to give you at 5,000 rupees. Now the market value of second hand Activa as well might be up to 50,000 rupees, but my friend is ready to sell it to me at 5,000 rupees. Then will the contract be void contract? The answer is no. Law says that not necessary that the consideration which is paid by the party should be adequate, means according either to the market value or according to what is the relevant prices in the market. It might be anything and everything which is agreed by both the parties. So even if the Activa, second hand Activa is costing 50,000 in the market, even if my friend is ready to sell it to me at 5,000, law has nothing to say about it, because contract ultimately is the party's wishes, it is the free consent of the party, it is the willingness of the party. So consideration need not be equal in value to the consideration which is given by the other party, but existence of consideration is necessary. Even if I am giving 1 rupee in exchange to a Honda City car, law will consider it to be a valid consideration, because under law even 1 rupee has got certain value in the eyes of law. Even if today in our generation as well 1 rupee might not be very important, but in the eyes of law 1 rupee is equal to 1000 rupees, equal to 1 lakh rupees. So instead of giving 10 lakh rupees for a Honda City, if I am purchasing it from my mother for just 1 rupee, then law says it is fine. If you both are okay with it, then Indian Contract Act does not impose or does not tell you to have equal consideration, but existence of consideration is necessary. Likewise, consideration must be real. Now the word real here means that it should not be illusionary, it should not be hypothetical, it should not be uncertain, it should not be impossible to do. For example, if you are giving 10,000 rupees to a magician and you are telling him to make a dead person alive, that consideration will not be considered to be valid consideration from the magician, because making a dead person alive is impossible, that amounts to physical impossibility. Likewise, to do certain things which are legally impossible, there cannot be a valid consideration. The consideration should not be uncertain. The word uncertain means it should not be vague, it should not be hypothetical. For example, if I write it in my contract that I am ready to sell my goods at a reasonable price, cannot be considered to be a valid consideration, because the word reasonable is not making anything clear. The word reasonable cannot mean 10,000, it cannot mean 20,000. So when you are talking about consideration, it must be certain, it should be fixed, it should have some value to it, it should be able to be interpreted. Likewise, it should not be illusionary. Illusionary means you should not do something just to fake your contract. For example, if you are signing an agreement with a police officer to go and perform his legal duty, you cannot say that it is a real consideration, because an agreement to perform a legal duty becomes illusionary. So consideration must be a real consideration. It should have some value in the eyes of law. The next important essential is that there must be an independent consideration to support each promise. Now, if I am a retailer, if I go to a wholesaler and I tell that wholesaler that I want to purchase 10 kgs of rice every day for next 1 month, I cannot say that I am going to purchase 10 kgs of rice on everyday basis. I will not give you the money for remaining 28 days. I will just pay you for 1 day, and that will be equivalent to the consideration for remaining promises. Law says that every contract must be supported by independent consideration. A single consideration cannot support two promises between the same parties. Likewise, consideration must be something which the promisor is not already bound to do. For example, a public duty, a legal duty, or something which you are legally bound to do, you cannot expect it to be a valid consideration. Meaning, for example, if tomorrow if I am a police officer, I go and arrest a thief, I cannot go to the house where that thief has committed theft. I cannot go to the house and say that I have brought all your belongings back which were stolen from you. You now give me 10,000 rupees as a consideration for our contract. A police officer is legally bound to go and catch hold of a thief, so he cannot be paid in return to the duty which he is supposed to do. Likewise, the consideration must be a promise to do something or abstain from doing something. To do something means it is a positive promise, that means I am giving you certain consideration, in return you perform some activity. Abstain from doing something is a negative consideration, wherein you are asking that person to stop doing something or not to do something. To give you a small example, let's say if I have given a consideration to a person, let's say if a person who could go and file a case against another person, if I give him some consideration and say that you should not file a case against me, it will be considered to be absistence from doing something. For example, let's say again, if I go to a person and I tell him that this is my old house, but I want you to not destroy it, I want you to not destroy this house, and to take care of my house I am giving you 10,000 rupees in return. This is a valid consideration, because here you are not telling a person to do something, but you are telling a person not to do something. So consideration might be a positive or it might be a negative consideration. You might ask a person to do something or you might ask a person not to do something. Both of it will be considered to be valid consideration. So under the Indian Contract Act, these are the essentials of valid consideration. In our next lecture, we will go through certain exceptions to the rule, wherein our rule is if there is no consideration, there cannot be a valid contract. So I'll see you all in our next session of consideration. Thank you so much.